Welcome back to my channel, or just welcome if you're new here. I'm Carmen Fourie. I'm an employment relations practitioner and also a small business owner. I've included an extensive list of my credentials just to give you some peace of mind on the content that I share. There are a lot of factors that go into buying and selling a business. And often in my experience, labor or the employees just don't get that much consideration. I've worked with a lot of clients who buy and sell businesses, as well as I've worked with businesses where the ownership has changed. And in my experience, I've often seen that most people don't even know that there are labor laws to be complied with. In today's video, I'm going to talk through the applicable legislation. I'm going to try to explain it in a way that's easy for you to implement into your business transaction, but also I'm going to share with you common mistakes that I've seen clients of mine or other business owners make when they're buying or selling a business as a going concern. I'm also going to share where there's a bit of a gap between what the legislation requires and what commonly happens in practice. I'm specifically speaking about buying and selling of businesses, or the transfer. It doesn't actually have to be a sale. It can just be a transfer of a business that is a going concern. What that means is the business is going to continue to operate indefinitely. I'm not speaking about the cases where a business needs to close down and cease operations. There you will follow the normal Section 189 or 189A retrenchment procedure, or if applicable, you will follow the insolvency or the liquidation procedure. Today, we're specifically speaking about businesses that will continue to operate indefinitely, even if you take a small break to maybe do some renovations. That's something we see quite commonly. Stay tuned in this video if you are planning on ceasing operations for a short period of time. I'm also not discussing when you purchase a shell company, so that's just basically purchasing the formalities or the structure or the title. I'm speaking here about companies that have employees, companies that have assets, companies that are currently trading and will continue to trade. Of course, given that I'm going to be discussing employment and labor considerations, if your company has no employees, then this video is also not applicable to you. One that is applicable but might look a little bit differently, and this one I get actually quite often, is where businesses rearrange their structure. So they have, for example, a holding company with a bunch of Pty Limited or CC or whatever type of company under it, and then you want to move employees around, or you want to move parts of the business around so that the holding company owns maybe that one but not this one, or you want to merge these two. You just want to change up business structures. Everything stays the same, but then you move your employees to a particular company because you want all of them to fall under the same company because it makes payroll easier. So those transfers must also be considered in this video. For today's video, I'm going to be taking you through Section 197 of the Labor Relations Act. Okay, got my Labor Relations book. Disclaimer in place. The reason or the purpose of this video is to generally explain the labor considerations around buying and selling or transferring a business as a going concern. My goal here is to explain it in an easy to understand way so that you can implement it yourself. However, this is not a consultation, so I'm not able to take individual factors into consideration. And if I were to discuss every exception to the rule or in detail explain every single technicality, I think I'd be defeating the purpose of this video, which is to provide a comprehensive but more general explanation of a transfer of going concern. Let's get into it. The most common question that I get asked is, do the employees need to sign a new contract of employment? This one I'm particularly asked when the structures have just changed. It's not necessarily a new owner, but this applies even if it is a completely new owner. And the long and the short answer is no. Technically, no. Contracts of employment automatically pass from the old employer, that's how the Act refers to it, so the old employer, meaning the person who used to own the business, to the new employer, the person who now owns the business. But here's my tip number one, is get those old contracts of employment, or look at those old contracts of employment prior to buying the business, or as soon as you have purchased the business if you haven't already done so. And then I will strongly recommend that you get somebody like me or your labor relations or employment relations practitioner to go over those contracts of employment. What I often do see is that the contracts of employment need to be redone, but that's because those previous contracts are non-compliant, or they're just not very good contracts, or they're not serving the purpose that they need to serve. But it's not a legislative requirement that the employees need to sign a new contract of employment. When you take over the business, the contracts automatically become your contracts. There is a document or a particular agreement that needs to be concluded, and that I will discuss a little bit later in this video, so hold on for that. But the contracts of employment, no. Another thing that often happens with the contracts of employment is that they are a total waste of paper. And this happens when the contract doesn't actually represent what is happening in the business. And this is where I strongly recommend that if you are still in contact, to ask certain questions to see whether the contract of employment accurately represents what is happening in practice. I have a strong aversion to generic templates that are used as contracts of employment. And my main reason for that is, firstly, they are a waste of paper because they don't accurately represent what is happening in that business. But more than being a waste of paper, they actually do damage. And the damage that is done is if your contract of employment doesn't accurately represent what is happening in practice. What's happening in practice will always override your contract, so the behaviors of the parties will become essentially the contract of employment rather than the piece of paper. Now, if that differs significantly, if your contract, for example, doesn't make any mention of any allowances that's paid, or it has a bunch of clauses in that are not enforceable, which we do see very often in template type contracts, then the trust in that document is completely tarnished. The trust, your policies, your contracts, it decreases the validity of the paperwork. I went on a slight tangent there about my aversion to templates, but the recommendation that I'm making here is ask the previous employer or the previous owner of the business very important questions around payments, because you inherit that stuff. Because of the way that sales go, practically it doesn't always work out that the new owner and the old owner or new employer, old employer can always sit down and talk through this stuff. My other recommendation for how you can very easily see if allowances are being paid is through obtaining samples of the pay slips. So I would suggest getting samples of pay slips, or even all of them if you can, depending on how many employees there are, for the different levels of employees, because you want to see, are there certain allowances that are being paid? Are there certain fixed increases? Are there bonuses? Are there certain deductions that you need to know about that form part of the terms and conditions, but these are not necessarily detailed in the contract of employment? So to conclude the question I get asked very often, do the contracts of employment need to be redone? Not necessarily, but I strongly recommend getting them, going through them, asking a lot of questions around the terms and conditions and looking at the pay slips to determine whether the contracts accurately represent what is happening in practice. Covers what is said in section 197 2A, and to B discusses specifically that you, the new employer, inherit or you get all of the obligations or the rights that the employees were entitled to prior to you taking ownership. And that's again why I'm saying find out what are the allowances, what are the benefits that are being given, because you get those benefits. Whether you like it or not, they are automatically transferred to you. If you don't like it and you do want to change them, you can't make unilateral changes to terms and conditions. That would be deemed unfair. Stay tuned in this video because I will get to how you can fairly alter the terms and conditions after you've taken over the business. Now, while you might be very tempted to change those terms and conditions because maybe you find that they really don't make business sense, or they are inefficient, or for whatever reason you feel like you do want to change them, a word of caution as to why I'm saying don't just unilaterally change them is because Section 186 of the Labor Relations Act defines the term dismissal. There are certain things that the word dismissal means. Section 186F refers to an employee terminated employment with or without notice because the new employer, after a transfer in terms of Section 197, so that's the section we're talking about, Section 197A, we're not going to discuss that one in this video. It specifically refers to transfers around insolvency. But back to the definition of dismissal: provided the employee with conditions or circumstances at work that are substantially less favorable to the employee than those provided by the old employer. So what that means is if you change the terms and conditions unilaterally and they are less favorable, meaning you take away some allowances or some benefits, it will be deemed a dismissal if the employee resigns. Also very closely related, Section 187 of the Labor Relations Act defines automatically unfair dismissals. So I had a lecturer who used to say, this is like a really big red light of do not do this because it's automatically unfair. In 187, and it reads, if the reason for the dismissal is, and we're particularly looking at G, a transfer or a reason related to a transfer contemplated in section 197 or 197A. So that speaks directly to the situation that we're dealing with here. If an employee is dismissed because of the transfer, and I'm not just talking about the unilateral changes to terms and conditions, if they are dismissed, you terminate their employment because of this transfer, then it falls into the automatically unfair category. That is not to say you cannot dismiss any employee, but the reason for that dismissal will not be the transfer. It will be either for misconduct, they broke a rule, capacity issues, poor work performance, medical incapacity, or any other type of capacity, or it will be for operational requirements. This will be technological changes that you make that decrease the number of employees needed, or it will be for a cost-saving exercise or a type of restructuring that you do. But you will follow the fair procedure set out by the Labor Relations Act to fairly terminate the employment relationship so that it doesn't fall within the automatically unfair dismissals. Back to section 197, we're on. It speaks to if the previous employer dismissed an employee who has now alleged that it is an unfair dismissal, or there was something that happened where the employee or employees alleged that there was an unfair labor practice. You, the new employer, you inherit the case that comes over from the previous employee. So the case might go to the CCMA as soon as you've taken it over, or it has just happened and you receive the arbitration award, but you inherit what the previous owner did. Is the one where I get the most misperceptions about, and how this usually plays out. I'll be chairing a hearing and I ask, how long has this employee been working? What I get is, since I took over the business in 2018, or since last year, June, when I bought the business, or something like that. And then I have to check and just be sure and ask, did you appoint this person as soon as you took over the business, or were they employed prior to you taking over the business? And that distinction is really important, because an employee's length of service is not how long they have been employed with you, the new owner, unless you appointed them, of course. It is how long they have been appointed or worked for the business as it has been operational. So the business name might change, the registered name might change, but it is how long have they been serving this business in this company, whether or not the ownership has changed. The length of service is a very strong, either mitigating or aggravating circumstance. It plays a big role in discipline as a whole, but also in operational requirements and also in your CCMA cases. So we've just covered section 197 to A to D. Moving on to section 197.3. This one says that you, meaning the new employer, cannot make the terms and conditions less favorable than they previously were. Now you might be watching this video thinking, okay, no, I understand. Obviously, I'm not going to do this. However, I've actually seen this one not happen intentionally, but rather unintentionally, because the new employer did not know about certain benefits or certain allowances or certain things that they were inheriting from the previous employer. And that's why I'm saying it's so important to get accurate information around what are the labor relations practices that are happening in this business that you need to know about, and make sure that you can then implement them or fairly consult to change them. Examples of how this has happened is if you look at the pay slips and you don't see any allowances or any benefits or anything getting paid out there, but you only looked at the pay slips from, for example, February through to June, and you didn't see anything funny there. But what you didn't know is that for the last 20 years, the company has paid annual bonuses. If a company has paid consistently annual bonuses over a period of time, there becomes this expectation from employees that it needs to be paid, and therefore you will need to pay these annual bonuses because it has consistently been paid by the business to the employees and has become part of their terms and conditions. So often non-compliance is not a malicious or an intentional thing. It is often, most often in my experience, a completely unintentional thing. One of the things that might be relevant to your business that I'm not going to explain in detail in this particular video is where collective agreements, or in particular bargaining council main agreements, come in. If you fall under the scope of a bargaining council agreement, you will need to refer to the main agreement of that bargaining council to determine whether or not there are any particular things that you need to do in the transfer of a business. The one bit of advice or tip I do want to give around collective agreements. So collective agreements are agreements that are concluded between an employer or a group of employers or employers' organizations and a trade union or a group of trade unions. The tip I want to give you is to just check whether or not employees in the business are unionized, so that you know whether or not you need to look at any type of collective agreements, any union agreements that were signed that you inherit and you need to abide by because they were signed by the business with the union. Whether or not you as the new owner signed it, it does automatically transfer to you. If you are in a situation where you're not able to contact the previous owner to ask this information, another way that you can try to verify this or to check, of course, you can just ask the employees if they are members of a union, but you can look at the pay slips. The union has enough representation to have a collective agreement, then they often also have an agreement to have their subscriptions deducted, meaning you as an employer deduct the union fees from the employee's remuneration before you pay it out, and you pay it over to the union. So you will see it on the pay slips as a deduction. One quick exception that you can change the terms and conditions that the Act specifically refers to is when you want to move employees from their previous provident fund over to your company's provident fund, as long as the benefit or the provident fund is similar to the one that they were on. We're moving on to discussing the only bit of paperwork that really does need to be in place prior to you taking over the business. If you have already taken it over and this paperwork is not in place, then just do it as soon as possible of having watched this video. Or thirdly, if you don't plan on implementing this at all, watch this video just so that you can understand what the possible consequences are and just make an informed decision. So this is the only part that's a little bit technical, I guess. And let me know in the comments if I've explained it in a way that makes it okay to understand. Now, this agreement needs to be in place between the old employer and the new employer and the employees. But employees doesn't just mean the people who are employed with you. Section 197 deals with the same kind of definition of what employees means here as with retrenchments. And how you got to do it is kind of like a hierarchy that you got to go down and check, is this bargaining body in my business, yes or no? And then kind of go down to see who you need to have this agreement with. Okay, so right at the top is there a collective agreement? So for example, you're part of a bargaining council that specifically specifies who you need to negotiate with the case of a transfer. So if yes, then you need to negotiate with whoever the specific collective agreement says you need to negotiate with. If no, then you move to the next one, which is there a workplace forum in the business? This one is very unlikely because there are not actually that many official workplace forums in South Africa. If there is no workplace forum, the next one is the trade union. This is a registered trade union, it's not just any trade union. If no trade union, then it falls to just the employees or anybody that they choose to represent them. And this brings us to the first part where the legislation differs significantly from what happens in practice, or at least in my experience. So I understand that the legislation says old employer, new employer, and employees, whatever that might mean in your specific scenario, need to conclude this agreement. However, what I've actually found, and I completely understand that most of the time, employees really want to participate in anything that has a material impact on their terms and conditions or on their employment. They want to have a voice. It's important. I believe in employee participation. I do. Everyone's waiting for my butt here. But in this case, I have genuinely found every single one of these that I've done, even the ones where trade unions are involved, the trade union and the employees did not want to participate in this. And you're going to understand why shortly. Genuinely, I have invited trade unions to these discussions. I have invited employees, and even if they did show up, they would kind of just sit there and it was boring for them because this agreement doesn't really have a material outcome on the terms and conditions of the employee. Who are really impacted by this agreement is the old and the new employer. What needs to be in this agreement and what needs to be negotiated? I've created a template for this agreement that you can use to, one, conclude the agreement, but also it can act as a checklist for you to make sure that you have discussed and finalized all of these points either prior to you taking over the business or very soon thereafter, or you're just mindful of it. To get the document, just go to the link below, and for a small fee, you can download it immediately. So as soon as your online payment goes through, the document is available for you to use. First thing that needs to be negotiated and detailed in this document is leave. Now, leave cycles run from when an employee starts, and then if it's an annual leave cycle, a family responsibility leave cycle, then it runs for 12 months. If it's a sick leave cycle, then it runs for 36 months, but they always run from when the employee started. So it's very likely that when you take over, some employees will be entitled to leave that has now accumulated that they have not taken yet. Who is responsible for that leave payment? Here's something that happens in practice that's technically not compliant. A lot of old owners say, it's fine, I'm going to pay out these leave balances to the employees, and then everybody starts on zero and their leave starts to build up from when the new owner takes over. The basic conditions of employment specifically refers to that annual leave can only be paid out on termination of employment. And Section 197, as we saw, states that their employment continues and is uninterrupted, meaning it does not terminate, meaning technically annual leave should not be paid out. The old employer then pays that amount to the new employer, just the amount of leave that is owed prior to you, the new employer, taking over the business, and you hold that amount so that when the employees take it, you pay that money out to them. Of course, the new employer and the old employer can agree to something different. When we talk about leave that's owed, here you're only going to negotiate annual leave that's owed, because the other types of leave you don't know in advance if somebody's going to take them. Now you might be starting to see why I'm saying employees don't want to participate in this agreement, because they're getting their leave either way. And you cannot agree to pay out the annual leave because that's contrary to the basic conditions. And we cannot, the common saying is, you can't agree to break the law. So although employees might want to get paid out that leave, that technically is not compliant. Along similar lines, if you take over the business mid-month, which of course is unlikely and it makes more practical sense to take it over probably right after payday, then you want to negotiate, is the owner going to pay it to you so that you can pay it at the end of the month, or are you going to pay it to the employees mid-month? Either way, the employees are getting their remuneration. It's just about when and how. To comply with the basic conditions of employment, you need to be sticking to your actual pay days and your timeframes with which you pay. Now, the final point that needs to be negotiated and agreed upon in this document, there can be more points that you discuss and agree upon. I'm just sharing the ones that are the minimum requirements by Section 197 of the. And this one is, remember I said you inherit the length of service. So what that also means is, for whatever reason, you need to retrench employees after you've taken over the business. You have inherited their length of services, and severance is calculated as a minimum. There can be, through consultations, negotiated a higher severance. But as a minimum, it is 1 week for every completed year of service. So suddenly, where you've only owned the business for 3 years, you're paying out severance for somebody who's worked there for 20 odd years. And that might be a lot of severance. With annual leave and with payments owed if you took over mid-month, you know those employees are entitled to that amount. Annual leave has to be taken in the 12-month cycle or within the 6 months after that cycle, but either way it's getting paid out to them or they're taking. Same with the mid-month payments. You know the employees are actually getting those amounts. So it makes sense then to negotiate with the previous owner to pay out those amounts so that you can pay it out to the employees. But with severance, it's not that easy because you don't know, and you probably aren't expecting, okay, we're going to split it, or there's going to be a particular ratio, but you're only going to pay me in future if this happens. Right, that brings us to the end of what needs to be in the agreement. It is leave, outstanding payments due, and severance pay. Like I said, you can use my template, but this must be discussed, and whatever you agreed upon must be in writing. and it must then be presented to the employees. The document that I've created is also the notification to the employees, because the employees need to have this information in writing. One of the main reasons that I am putting so much emphasis on this agreement is because if you don't conclude it properly, or if there is any gray areas, Section 197 also says if in the 12 months following the transfer an employee becomes entitled to the benefits or the amounts of money that was due to them, or there's a dismissal due to operational requirements, i.e. retrenchment, if this agreement was not done properly, or there's no agreement in place with the new employer and the old employer, there is joint and severable liability. So both of you will then have to go to the CCMA unless the old employer can show that this agreement was done properly and that they are not required to pay out anything or to participate in the CCMA. Just quickly, joint and severable liability means that both parties can be held jointly liable. So the two, the old and the new employer, can be held liable, or it can be severed and only one of the two can be held liable. And to conclude this video, I said that I would discuss how you, as the new employer, if you've inherited terms and conditions that you do not want and you do not fairly alter them, because remember, you cannot make unilateral changes to terms and conditions. The fair way to go about doing this, and I'm specifically speaking about terms and conditions. So if you want to make changes to the terms and conditions, for example, you want to change it from paying somebody weekly to paying everybody monthly. You no longer want to do cash payments, you want to only do EFTs, you want to change payday, you want to take away some allowances or some benefits, you want to ask certain people to work night shift that don't usually work night shift, and things like that. So those are just a couple of examples. That is not an exhaustive list. How you go about doing that is you do it in consultation with the employees. And this is often where people like me come into play, where we negotiate with the employees, but you can also do it yourself. You can sit the employees down and you can have a transparent conversation with them about the needs of the business and negotiate back and forth to try to come to a win-win scenario for everybody. But how you fairly alter terms and conditions is by agreement. And that brings us to the end of today's video. If you found this video helpful or the information helpful, please remember to like and subscribe to see employment relations videos every Thursday, or if you're interested in my lifestyle videos, those come out on Tuesday. Or comment if you've got any questions or any topics that you want me to discuss in future. Let me know. Your feedback is super helpful for me to create quality content for you.